Hi everyone, it's Carolyn from True Crime Chat with Mommy Ramblings, and I'm here with some information about the Scott Peterson appeal hearing that's going to be happening tomorrow, June 2nd, 2020. It's 1:30 p.m. Eastern Standard Time, and it will be able to be accessed. You can watch it as it happens. I'll put a link to that in the video description. So will he get a new trial? What are the grounds of the appeal? We're going to go over that now. If you're brand new to the channel, we'd love it if you'd subscribe and become a member of the greatest community on YouTube. Just click that little subscribe button in the corner of the video, the bottom corner. Click the notifications bell so you'll know every time we go live. And we do a lot more than true crime here, live or upload a new video, but we do a lot more than true crime here. We have all kinds of content, from fun interactive games and talk show type panels to grief management support, true crime, shopping hauls, live crafting. It's a full lifestyle channel. I think you'll really like it here. So let's get on and look at what's going on here in this appeal hearing tomorrow. Scott Peterson, as I said, is having that appeal hearing June 2nd, tomorrow, 1:30 p.m. Eastern Standard Time. The defense is appealing his conviction and death penalty sentence due to several issues. They want that conviction and sentence overturned, and they say he did not receive a fair trial. Just to backtrack, in November of 2004, a jury convicted Scott Peterson of the murder of his wife, Laci Peterson, and then sentenced him to death the next month. Let's go over the timeline before we go into the appeal, just to get everybody's mind refreshed with this case since it's been some time. December 24th of 2002, Laci Peterson was initially reported missing from the couple's home in Modesto, California. On January 24th, 2003, a woman named Amber Fry, who was a Fresno massage therapist, came forward at a police news conference and told the public that she was having an affair with Peterson. She said the affair began November 20th and that Scott Peterson told her that he was single. On April 18th, 2003, California Attorney General Bill Laci confirms a body found on April 13th in the San Francisco Bay Area shore is that of baby Connor, and a body found in the same location on April 14th is that of Laci Peterson. On April 18th, 2003, Scott Peterson was arrested in San Diego, pending capital murder double homicide charges, and was held without bail. On April 21st, 2003, there was an arraignment in Stanislaus County Supreme Court before Judge Nancy Ashley. Scott Peterson was charged with 2 felony counts of murder with premeditation and special circumstances. Scott Peterson pled not guilty. Under California law, the special circumstances allow the prosecution to seek the death penalty. There are 2 counts because of California's fetal homicide statute. Any fetus, meaning 8 weeks of development and onward, is considered an equal victim. On May 2nd, 2003, Mark Garagos becomes Scott Peterson's attorney. June 12, 2003, a gag order was put in place on participants saying the restrictions were necessary to preserve Scott Peterson's right to a fair trial amid massive publicity. On August 18, 2003, Judge Al Girolami rules that news cameras will not be allowed in the courtroom at the preliminary hearing. September 26, 2003, Laci Peterson's family files a civil lawsuit against Scott Peterson in Stanislaus County Superior Court to prevent him from receiving money for selling his story. On October 29, 2003, preliminary hearing, DNA and forensics evidence is presented. On December 3rd, 2003, Scott Peterson pleads not guilty at his formal arraignment. On December 19, 2003, Laci's mother, Sharon Rocha, sues Scott Peterson for over $5 million for the deaths of her daughter and unborn grandson. As the executor of Laci Peterson's estate, Sharon files 2 separate lawsuits in the Stanislaus County Supreme Court, a wrongful death action and a survival action. January 20th, 2004, the trial is moved to San Mateo County. February 2nd, 2004, Judge Alfred DeLucci bans cameras from the San Mateo County courtroom for the entire trial. March 4th, 2004, jury selection begins. March 27th, 2004, the 6-man, 6-woman jury is seated in the case. There are also 6 alternates. June 1st, 2004, trial begins. June 21st, 2004, Judge DeLucci tells jurors that they must take care to ensure their actions in and around the courtroom are not misconstrued. And that warning came after juror number 5 spoke to Laci's brother, Brent Rocha, at a courthouse security checkpoint on June 18th. On June 23, 2004, juror number 5, Justin Falconer, was dismissed from the jury. August 10, 2004, Amber Fry testified that Scott Peterson told her he was a widower and he lied about where he lived and where he traveled. The jurors heard recordings of Scott Peterson's and Amber Fry's conversations, and those were made by police after she discovered the truth. She helped them, get these charges filed on Scott by having that recording device attached to her phone, and she recorded their conversations. October 5th, 2004, the prosecution rests. October 26, 2004, the defense rests. November 1st, 2004, the prosecution made its closing arguments. November 2nd, 2004, the defense began its closing arguments. November 3rd, 2004, the jury deliberations began. November 12th, 2004, Scott Peterson was found guilty of first-degree murder for Laci's death and second-degree murder for their son Connor's death. The first-degree charge usually carries a potential sentence of 25 years to life with a chance of parole, but in this case, the jury found that special circumstances apply in Laci's death, and he could face a death sentence or life in prison without parole. The second-degree charge carries a potential sentence of 15 years to life. November 30th through December 9th, 2004 was the penalty phase. Laci's mother Sharon testified, crying and even shouting at Scott Peterson several times. Scott Peterson's parents and half-sister testified for the defense. On December 13th, 2004, the jury recommended that Peterson be sentenced to death. On March 16, 2005, Judge Alfred DeLucci follows the recommendation of the jury and sentenced Scott Peterson to death. On October 21st, 2005, a judge ruled that proceeds from a $250,000 life insurance policy that Scott Peterson took out on Laci will go to Laci's mother, Sharon. On July 12, 2006, Scott Peterson gives a videotaped deposition for $25 million wrongful death lawsuit filed by Laci's family. On October 31st, 2007, the 5th District Court of Appeal reaffirms an October 21st, 2005 ruling that Sharon Rocha should get the $250,000 life insurance payout for Laci's death. On April 2009, Laci's parents dropped the wrongful death lawsuit against Scott Peterson. On July 5th, 2012, Scott Peterson's automatic appeal is filed in the California Supreme Court. On March 13th, 2019, Governor Gavin Newsom signs an executive order issuing a moratorium of executions of all 737 death row inmates in California prisons, including Scott Peterson. This only suspends executions while this Governor Newsom is in office. Now let's go to that appeal. The reasons for the appeal, according to the brief, include the judge's failure to move the trial a second time, despite massive pretrial publicity that portrayed Scott Peterson as guilty. The judge dismissing potential jurors opposed to the death penalty without determining whether they could put that aside and follow the law, and allowing the prosecution to present questionable and suspect evidence. That includes allowing a dog handler to testify about the results of her dogs tracking the scent of Peterson's wife, Laci, despite a lack of scientific basis for that evidence and the dog's abysmal record. A letter filed with the court from the Attorney General's office states it expects the focus of Tuesday's hearing to be on the trial judge's decisions to dismiss potential jurors from the trial and not to move the trial a second time. The trial was moved about 90 miles from Modesto to Redwood City because of the overwhelming pretrial publicity in Modesto, but defense attorneys argued that that was not sufficient. Nearly all of the prospective jurors in the San Mateo County knew about the case, and nearly half already had decided Peterson was guilty based on questionnaires they filled out. According to court records filed by Scott's legal team, said the judge refused to move the trial to Los Angeles County, which among California counties has the lowest rate of people who had already prejudged the case. So this letter from the prosecution dated May 22nd, 2020 to the court says the focus of the conversation Tuesday is going to be about those two major issues. They say first, was it improper to exclude jurors during the voir dire or jury selection who directly expressed or possibly had an objection to the death penalty, particularly when they indicated they would consider death nonetheless. Now, as the defense explains, the trial court here discharged juror after juror simply because they stated in their written questionnaire that they were opposed to the death penalty. And the court's interpretation that this is the law in California is wrong. The state emphatically disagrees by claiming these jurors were substantially impaired in their ability to consider both penalties. Second, should the defense's motion for a change of venue have been granted? The defense says yes, considering the enormous pretrial publicity. And as they cite, not only had all of the actual jurors already been exposed to the facts of the case, but half of those prospective jurors also thought Scott Peterson was guilty. Despite the defense's pleas of unfairness, the state counters that Peterson's case was heard by an impartial jury and San Mateo was in fact the best venue for the trial. Now, besides the automatic appeal of Scott Peterson's death sentence, Scott Peterson has what is called a petition for habeas corpus pending with the court. And unlike the automatic appeal, which focuses on alleged errors made by the trial judge, the petition can introduce new evidence to show the conviction or sentence was wrong. So I'm just going to go over some of this over 200-page document. I will put a link to the entire document in the video description if you would like to read it, but let's take a look at this, okay? So errors relating to jury selection. The trial court's improper discharge of 13 prospective jurors over defense objection requires a new penalty phase. Okay, let's see what happens here. And then you have number 2, the trial court's improper discharge of 13 prospective jurors based solely on opposition to the death penalty also requires reversal of the convictions. 3, the trial court violated state and federal law in denying Mr. Peterson's motion to change venue and forcing him to trial in a county where nearly half of all prospective jurors had already concluded he was guilty of capital murder. Court violated the Constitution in giving a one-sided instruction on how the jury could use the dog scent evidence presented at trial. The trial court violated both state and federal law by admitting expert testimony that Connor was placed in the water where Mr. Peterson had been fishing. And then 8, the trial court erred in excluding critical defense evidence, refusing to allow the defendant to test evidence absent the presence of the state prosecutors, and refusing to grant a mistrial after the jury performed an experiment during deliberations. The trial court's ruling precluding defense counsel from investigating this portion of the defense case unless the prosecution team was present cannot be found harmless. The jury's stability experiment on the boat during deliberations requires reversal, and that was that reenactment that the defense did where the boat, they were trying to show he could not have put Laci's body into the water himself. The boat would have capsized. That's what they're talking about there. And let's just go over the introduction here. The guilt phase in this case, from opening statements to verdict, lasted a full 6 months. The trial as a whole, including juror voir dire and the penalty phase, lasted approximately 10 months. In a trial this long, it stands to reason that mistakes can and will occur. After all, as the Supreme Court has noted, there can be no such thing as an error-free perfect trial. In his opening brief, Mr. Peterson recognized that he was not entitled to a perfect trial, only a fair one. He contended that because of various errors committed by the trial court, he did not receive the fair trial to which he was entitled. The state had filed its 475-page respondent's brief, the state's initial position in that, remarkably enough, Mr. Peterson actually did receive a perfect trial. According to the state, at no point in any portion of this 10-month trial did the trial court commit even a single error. The golden fleece has been found. In the state's view, for example, the jury selection process was perfect. The trial court committed no errors at all. Thus, it was entirely proper for the trial judge to dismiss 13 jurors based solely on the judge's stated belief that if you don't support the death penalty, you cannot be death qualified. It was entirely proper to hold a trial in a county where 96% of the prospective jurors had been exposed to adverse publicity about the case, and 46% of that group admitted to reaching a judgment about guilt before hearing testimony from a single witness. 98.6% of those prospective jurors believed Mr. Peterson was guilty, and more than half of the 98.6% conceded they would not set aside their views and judge the case based on the facts presented at trial. The state takes the same approach to the 6-month guilt phase. Once again, the trial court committed no errors at all. Thus, it was entirely proper to admit dog scent evidence based on a scenting technique that, as discussed more fully below, has never been admitted in any court in the country. It was entirely possible to permit state's acknowledged expert on tides to testify not about tides, but about the movement of bodies in water, even though the expert himself candidly conceded he was not an expert in that area. It was entirely proper to admit prosecution testimony about stability experiments on a model of the boat Mr. Peterson owned, performed in a freshwater Indiana swimming pool a full 25 years before trial, while excluding defense testimony about stability experiments performed on the same model boat, but done in the actual area of San Francisco Bay where the crime was alleged to have occurred, at the same time of the day as the crime was alleged to have occurred, and using mannequins and participants specifically sized to the actual weight of those alleged to have been involved, and having excluded such defense evidence in part because Mr. Peterson's actual boat had not been used. It was then equally proper for the trial court to refuse to allow the defense to use the actual vote for an experiment unless members of the prosecution team were there to personally observe any defense experiments. These and other errors will be discussed in detail below, but it is important to note at the outset of this brief that, contrary to the state's position, the trial in this case was certainly not perfect, far from it. Mr. Peterson will end this introduction where he began. Although a defendant is not entitled to a perfect trial, he is entitled to a fair trial. The question to the court to answer here should not be obscured by the state's insistence that no errors at all were made at trial and that this was the perfect trial. The real question for the court is whether it can be said with any confidence that Mr. Peterson received a fair trial in light of those errors which did occur at trial. It is to that question Mr. Peterson now turns, given the exacting standards which must be applied to capital cases and the nature of the numerous jury selection, evidentiary, and instructional errors which occurred at trial. The answer to this question is clear. Reversal of both the penalty and guilt phases is required. The argument, errors relating to jury selection. The trial court's improper discharge of 13 prospective jurors over defense's objection requires a new penalty phase. And during the voir dire, the trial court discharged 13 prospective jurors based entirely on their written answers to several questions on the jury questionnaire, and there was no questioning of any of those 13 prospective jurors. The juror questionnaire answers of each of those 13 jurors indicated that they were opposed to the death penalty, but their views on capital punishment did not preclude them from imposing death. There was no mystery as to the trial court's reasoning in discharging any of these 13 prospective jurors. In fact, the trial court put its reasons for discharging each of these 13 jurors on the record. As to each, the trial court stated that Wainwright versus Witt, 1985, permitted their discharge based solely on their death penalty views. Because defense counsel had a very different view of the Witt standard, he objected to each and every one of the court's discharges. He repeatedly advised the court that it was making a mistake because mere opposition to the death penalty was not a sufficient basis for discharging a juror. Defense counsel explained that Witt permitted discharges only if a juror's death penalty views would prevent the juror from imposing death. The prosecutors stood mute. At no point during any of these exchanges did anyone on the prosecution team step up to the plate and say anything. At no point did either of the prosecutors ever advise the trial court that its understanding of the Witt standard was wrong. Instead, the prosecution team permitted the trial court to discharge juror after juror simply because, as the trial court put it, under Wainwright versus Witt, if you are opposed to the death penalty, you are not qualified to serve as a trial juror in this kind of case. In his opening brief, Mr. Peterson contended that the trial court's interpretation of Witt was wrong, and the decision to discharge these 13 jurors violated the Constitution. More specifically, he raised 4 separate contentions. The state has now responded. Although the state ultimately defends every one of the trial court's discharges, it concedes 3 of these 4 contentions. First, because the trial court discharged these 13 jurors based entirely on their answers in the jury questionnaire without any voir dire, the court's rulings were not entitled to defense, but were instead subject to de novo review by this court. In this situation, the discharges may be upheld only if the written answers leave no doubt that the prospective juror cannot set aside his or her own views and follow the law. In several cases, after Mr. Peterson's opening brief was filed, the court has reiterated these principles. Prospective jurors may be dismissed based on written questionnaire responses alone if the responses leave no doubt that their views on capital punishment would prevent or subsequently impair the performance of their duties in accordance with the court's instructions and the juror's oath. In reviewing dismissals for cause based upon only written answers, we apply a de novo standard of review. In its brief, the state concedes that 1. When a juror is discharged without voir dire, but instead based solely on written answers in a jury questionnaire, the court's review is de novo and discharged based on a jury. Questionnaire is only permissible when it is clear from the answers that the prospective juror is unwilling to follow the law. Second, a prospective juror may not be discharged simply because he or she is opposed to capital punishment, but only where the record shows the juror's views would prevent or substantially impair the performance of his or her duties as a juror in accordance with his instructions and his oath, and in its state's burden to prove a juror meets the criteria for dismissal. The state properly concedes this as well in its brief. Third, the improper exclusion of even a single juror based on opposition to the death penalty requires a new penalty phase. In its brief, the state concedes that if the court finds even a single juror was improperly discharged under wit, a new penalty phase is required. Recognizing that under existing United States Supreme Court precedents, the erroneous excusal of a prospective juror for cause based on that person's views concerning the death penalty automatically compel the reversal of the penalty phase without any inquiry as to whether the error actually prejudiced the defendant's penalty determination. Finally, in his opening brief, Mr. Peterson conceded that the answers of the 13 jurors to questions 107 and 109 of the jury questionnaire showed that each of the 13 discharged jurors opposed or strongly opposed the death penalty. But he went on to note that each of these 13 jurors also answered questions 115, explaining that their views would not make them unable to impose the death penalty. Regardless of the facts, thus on the fact of the jury questionnaires alone, none of these jurors was excludable under wit. And it is here that the state disagrees, making two arguments. First, the state argues that jury questionnaires actually do show that every one of the 13 jurors was unable to follow the law and consider death as an option. In other words, discharge under wit was proper. Okay, and then we have the trial court's admission of a type of dog scent identification evidence which had never before been admitted in any case in the country, and its decision to do so absent a scientific basis showing the evidence was either reliable or generally accepted requires reversal. The state's theory of this case was that Mr. Peterson killed his wife in Modesto and put the body in his truck for transport to his warehouse. Under the state's theory, at the warehouse, he put Laci in the boat, attached the cement weights to her, and fully covered the boat. He then drove to the Berkeley Marina and backed the boat down the landing ramp with a cover on it. After he parked his truck, he took the cover off the boat, used it to cover Laci's body, and motored into the bay. 4 days later, on December 28, 2002, dog handler Eloise Anderson brought her trailing dog, Trimble, to the Berkeley Marina. Anderson was not asked to use Trimble to check the marina generally for any of Laci's scent. Instead, she was asked by police specifically to search the boat ramp and the adjacent pier for Laci's scent. In order to accomplish this goal, Anderson had to give Trimble an item with Laci's scent on it. Anderson used a pair of sunglasses taken from Laci's purse. Anderson knew at the time that Scott had handled the purse. She did not know if Scott had handled the sunglasses themselves, and she failed to perform a missing member test to ensure Trimble did not search for Scott's scent rather than Laci's. This failure was important because the sunglasses had been collected by the dog handler, Cindy Valentine, who picked up the glasses after picking up Mr. Peterson's slippers. Anderson explained that when a dog detects a scent, what it is really detecting are skin rafts, microscopic skin cells that come off a subject. According to Anderson, Trimble detected Laci's skin rafts near the boat ramp and followed the trail onto the pier and out to the end of the pier. Trimble detected these skin rafts even though it was conceded that only Scott, not Laci, had actually been exposed to the open air on the boat ramp and on the pier. Yet, according to the prosecutor, this evidence established guilt of capital murder, as simple as that. In his opening brief, Mr. Peterson contended the trial court violated both state and federal law in admitting the dog scent evidence because the evidence did not meet the foundational requirements for admission of dog scent evidence under state law. And 2, the evidence was too unreliable to admit in a capital case under federal law. Admission of this evidence required reversal because the case was close and the nature of the dog evidence was highly incriminating. The state disagrees. The state first argues the admission of the dog scent evidence does not violate state law. Turning to the federal law component of the claim, the state argues the claim was waived by trial counsel's failure to cite the 8th and 14th Amendments when he made the objection. Finally, the state argues that any errors were harmless. Mr. Peterson will address each argument in turn. As discussed more fully below, the dog scent identification offered in this case was unique. Unlike most cases involving dog scent detection, the state did not use Trimble to detect the scent of a suspect fleeing on foot. Instead, the state claims Trimble detected Laci's skin rafts, which had emanated from a closed vehicle, the covered boat in which the state theorized she had been brought to the marina. This, even though Trimble's training history showed that in such searches she was wrong 67% of the time. No court in the country had ever admitted the results of this kind of dog scent identification. And 3, one of the state's own experts admitted there was no agreement on whether this kind of scent detection was even possible. Okay, so that is what's going to be the major focus tomorrow. And we will cover, I will watch that at 1:30 p.m. Eastern Standard Time. I'll put a link in the video description so we can watch it and discuss it after. But I did, again, not go over the whole 200-page document. I just picked some key parts to read to you. And I will put a link to the entire over 200-page document so you can go through it, at your leisure as much as you want. There's a lot, it goes over each and every juror and everything there. So remember that, put it on your calendar for tomorrow, 1:30 p.m. Eastern Standard Time. And again, we will come back and discuss it. But thanks for watching. You can put any questions in the comments or any views, and we will discuss this more tomorrow. Take care and have a good day, guys. Bye.